Professor Josep Joan Moreso is a Catalan legal philosopher who works at the Pompeu Fabra University. He is in Spanish nomenclature catedrático. It means the highest possible academic rank. And it's worth to mention that in 2005 he was elected as a rector of the Pompeu University after he was re-elected in 2009. So 8 years he was a rector of his home university. He holds also 2 degrees of doctoris honoris causa from the University of Valparaíso in Chile and University Antenor Orejo Trujillo in Peru. Yes. So Professor Moreso is analytical legal philosopher. His works are characterized by, I would say, interdisciplinary approach because he combines linguistics analysis with logical analysis, with meta-ethics, with political philosophy, with theory of interpretation, with theory of constitutionalism, etc. So his works are really very interdisciplinary. He has published about 10 books and more 200 papers and book chapters. Yesterday I checked his account at Google Scholar, and on Google Scholar 248 works of Professor Moreso are listed. So it's a lot. His works are mainly written in Spanish, but some of them were published also in English or translated into English. For instance, a book, Legal Indeterminacy and Constitutional Interpretation, which Professor Moreso wrote during his stay in Oxford. His host in Oxford was late Professor Joseph Ras. And also 2 papers I would like to mention. A paper in defense of inclusive legal positivism published in 2001. And the second paper written with Professor Pablo Navarro, Applicability and Effectiveness of Legal Norms, which was published in Law and Philosophy in 2005. Of course, we are very happy that Professor Moreso has accepted our invitation for the school. And please, the floor is yours.
Thank you very much, Professor Grabowski. I am very thankful for this invitation. Really, it's my first visit to Krakow and my first visit to Poland, and I visited it these days even Auschwitz, and I am very shocked and very impressed by that. And Krakow is a very important city in the history. It's a very interesting and a very nice city in my view. I am very thankful for the invitation to participate in this summer school in the Jagiellonian University, and I am especially particularly thankful. All to the director of the school, to the Professor Thomas Gisbert-Stunicki, but particularly to Professor Grabowski. I met Professor Grabowski in Spain during his long period in Spain, in Alicante, one department of legal philosophy very close to me even, and for the kindness and the facilities and the information, even with the problems, the possible problems with the flights, because Ryanair is threatened with a descommunal strike, and in this sense, I am very thankful to Professor Grabowski. Thank you. My presentation, even that this is one summer school between constitutional law and legal theory, and constitutional law particularly. One issue who concerned me, which concerned me for a long period, and now, which is the problems, the ways of solving conflicts among constitutional rights. It's very usual to find in the decisions of our constitutional courts and even international courts, European Court of Human Rights, Inter-American Court of Human Rights, and so on. These kind of problems. And it's a challenge for legal theory, in my view, to determine how we could solve these kinds of problems. I would like to start presenting, Thank you. Presenting three cases, in fact, three different cases of conflict of constitutional rights. The first is very known. It's the preferred case of Robert Alexi, always presenting this case of Titanic and the conflict between freedom of the speech and freedom of information and the rights, personality rights. But there are two cases, different cases. The first very tragic case, the third, the second, different. You see, but I think these cases are able to put on the table the kinds of problems concerned to the conflict of rights. Well, Titanic. Perhaps you know the case, perhaps you know. This is the case of a collision between the freedom of expression and the general personality right, in which a widely published satirical magazine, Titanic, used the expression like a war murdered, and in a later edition, a cripple, in order to describe a paraplegic reserve officer who had been called again to active duty in order to participate in a military exercise in Germany. The Düsseldorf Higher Regional Court of Appeal ruled against Titanic in an action brought by the officer and ordered the magazine to pay damages in the amount of this quantity of German marks. In its turn, the magazine brought a constitutional complaint, and the German Federal Constitutional Court, perhaps the most important court in Europe and most influential court in Europe, considered that whereas the description war murdered was a moderate or even light interference with the personality right when placed in the context of the satire of this satiric magazine, and therefore the interference with the freedom of expression was disproportionate, the description crippled against to a paraplegic person counts as a very serious interference with his personality right, and in this case, the freedom of speech should be sacrificed. In the Titanic's case, the constitutional complaint only was justified referring to the description war murdered, while regarding the description crippled, the magazine was rightly ordered to pay damages in the reserve officer. This is a very famous case in virtue of the development of Alexi. Alexi for 30 years take this case as the example of his ideas about proportionality and about balancing I present after. This another case, this different case, is a case by the Spanish Constitutional Court, but is a case with differences, but typical in our jurisdictions, in more jurisdictions internationally. On 1994, this child, Marcos, then 13 years old, who lived in a little village in Aragon, Spain, in the north of Spain, with his parents, fall driving his bicycle. Some days after, Marcos had various copious nasal discharges of blood. With his mother, he visited a doctor in the village who strongly recommended to be admitted in the hospital near Lleida. In the hospital decided this is better to go to Barcelona, to go to a hospital in Barcelona, and doctors said that was necessary, totally necessary, indispensable intervention, medical intervention, and producing a blood transfusion. But the family was Jehovah witnesses, and in this sense, they manifest, they show his opposition, their opposition to the transfusion, to the blood transfusion. Well, doctor said that the transfusion is the only remedial disposition, and parents, knowing that in Spain and in general in the world, minors are not able to reject the transfusion, they decided don't oppose to the transfusion. But when the transfusion was tried, Marcos with violence reject the transfusion because he was convinced about these convictions, and doctors said that was not possible in that conditions to produce the transfusion. And at the end, retired abandoned the hospital, come back at home. At home, there is very difficult situation. At the end, the situation is very, the illness is very, very increasing. And at the end, when was driven to the hospital, he was admitted, died in the hospital. And this put a question. Marcos' parents were charged with the crime of murder, something like gross negligence, manslaughter by omission. I don't know, I'm not sure about in English this idea, but with our continental tradition, the idea is that the parents has a position of guarantee, and in this sense is an homicide in Spain. The way to say that is commission by omission. And in fact, at the end, the Spanish Supreme Court, our court of cassation court, in fact, decided to convict and to declare guilty of murder to the parents with the qualified extenuating circumstance of obfuscation, and sentenced them to 2 years and 6 months imprisonment. Marcos' parents brought a constitutional complaint, and the Constitutional Court in 22 decided that the constitutional complaint was justified because the decision of the Spanish Supreme Court violated the freedom of religion, a civil right guaranteed by the Spanish Constitution, obviously, and in consequence annulled the Supreme Court's decisions. I put this case, I'm interested, or was interested in this case, because this case is a case, is quite, but it's a case of conflict between the right of life and the religious freedom. And this is very different of usual conflicts of rights, but this is the question, no? And third case is more, I don't know, more anecdotic case, but has certain interest. An Italian professor of philosophy of law, very reputed Italian professor at the University of Florence, public university, Professor Luigi Lombardi Balauri, had been teaching a part of University of Florence, the subject, philosophy of law, also in the faculty of law at the Università Cattolica del Sacro Cuore in Milan, since 1976, on the basis of contracts renewed on an annual basis. When the competition for this 98-99 academic year was called, Lombardi Balauri applied again, as the last 25 years. The Congregation for Catholic Education, an institution of the Holy See, sent a letter to the president of the university informing that some of the ideas of Professor Lombardi Balauri were in clear opposition of the Catholic doctrine, and that in interest of truth and of the well-being of students and of the university, the application of Professor Lombardi Balauri should not be accepted. In October 98, few days after, the university president communicated to the dean of the Faculty of Law the position of the congregation. At the beginning of November, the faculty board, in accordance with the Vatican's position, decided to ignore Lombardi Balauri application, given that one of the conditions for admission to the competitions had not been met, namely the approval of the Congregation for Catholic Education. Well, it seems that some of the applicants' opinions about some dogmas of the Catholic Church were considered heretic, particularly his curious assertion that hell represented a form of cruel, inhuman, and degrading punishment, and thus was unacceptable by standards of law characteristic of civilized countries. However, the university authorities never expressed the reason to Professor Lombardi Balauri. In fact, Lombardi Balauri was a very important Catholic intellectual, a member of a family of very important Catholics in Italy, but at the end, during this period, changed his mind to different positions and become more critical to certain dogmas of Catholic Church. The further applications of Professor Lombardi Balauri to the Regional Administrative Court and to the Consiglio di Stato, the Conseil d'État, Italy has an administrative justice like France, this is the idea, were dismissed. The main argument was that the concordat between the Holy See and the Italian Republic required the previous approval of the Holy See for the appointments of lecturers at Catholic universities, and moreover, an important decision of the Italian Constitutional Court had ruled that this mechanism of previous approval was compatible with the Italian Constitution, which guarantees both freedom of instruction and freedom of religion. This is the consideration that this is an ideological institution, an ideological institution set our course in general, who are able to put additional conditions to be hired for this institution, additional conditions. I mean, it's possible that, I don't know, a society, as a club of hunters, could dismiss one person because he or she becomes a totally defender of animal rights. For instance, that's usually, of course, said, well, this is possible to defend animal rights, but if you are a member of a club of hunters, it's normal that the conditions are in this way. Well, But Lombardi-Balauri, a professor of law, appealed to the European Court of Human Rights, and the court decided that the interference with the freedom of expression in this case was not justified. The lack of justification arose from the omission of the explanation of how the applicant's view, allegedly contrary to the Catholic doctrine, had affected the university's interests. Because of this, the faculty board had not given adequate reasons for ignoring the new application after 20 years of uninterrupted renewals of Professor Lombardi-Balauri. The question is, the core accept the complaint of Professor Lombardi-Balauri with the argument that the institution, the Catholic University of Milan, is unable to give reasons to the dismissal, to give reasons. This is the expression, to give reasons. Giving reasons is the point of that. Well, this is the three cases. What's the problem? What's the problem? The problem is that the standard conception of application of law is as follows. Applying law means subsuming a particular case in a generic case correlated by a rule or principle or a standard that is not relevant now with a legal consequence. And if I am able to show that this action of A is an action of commit murder, is an action of to kill another person, then I could subsum elaborating or doing this operation of subsumption in a generic rule, and this rule correlate this action with normative consequence. This is our conception of applying law. And in this sense, applying law presupposes an image of law as a possibility to consistently derive consequence of our set of rules. But the problem is how about the particularist challenge? It's obvious that it's acceptable. It's acceptable that our legal system, our notion of application of law, of legal application, works in this way. For instance, we could reflect about moral rules. There is a moral rule that establishes the duty to keep promises. But to keep promises always, let me suppose that someone replies that urged by a promise to kill someone, the moral principle that obliges to keep promises must be reformulated as follows. Provided that one's promise is not undertaken to do something immoral, then it supplies one with a moral reason to act so as to keep it. But now the particularists could add, to press the generalists, what if the promise has been obtained through the threat of kidnap, for instance, the daughter of the promisor? Then the generalists would reformulate the principle again, in the sense, provided that one's promise is not given under threat and is not undertaken to do something immoral, then it supplies one with moral reason to act so as to keep it. Next, the particulars could posing the case that, for instance, this is an example of Jonathan Dempsey, for instance, that a torturer who promised under threat to abandon the torture, then she has the duty to keep the promise, and the generalist could always add the adjective unjust in the substantive threat, and so on. That is precisely what the particularist account considers, that there is no plausible way, according to particularist account, and there is no plausible way of ending this, and so on. the diversity of the context makes it impossible to hold a valid moral principle of invariable sense in any concept. And accepting this challenge produces a very problematic situation, the application of law, because if one accepts the particularist challenge, the substantiation is not possible, because the substantiation is always depending of this I don't know, this capacity to show a new property able to defeat the decision. This is problematic, and this is problematic in moral philosophy. There is a huge debate in moral philosophy about that, and this is problematic in law, because law is perhaps the standard practical normative considerations in which we are very used to use this rule exception device. The law is in this sense at first glance very, I don't know, very divisible, because we are really it is really usual in law that there is the rule, the prohibition to kill anyone, but the exceptions, justification, causes, excuses, and so on. And this is usual in law. This is very usual. But this produces in the logical, even logical literature, in intelligent artificial intelligence and informal logic, the idea that our arguments, our reasoning is not monotonic. What means is not monotonic? It's non-monotonic, in fact. Monotonic reasoning doesn't accept two very usual to central, crucial properties of usual logic. That is, logic, classical logic, is monotonic, and in virtue of his monotony, is able to accept the rule of modus ponens. The rule of modus ponens is necessary to conclude that if A kills another man, should be punished to the sanction S, and I don't know, John kills Mary, then John should be punished to the sanction S. This is the modus ponens. But non-monotonic reason is enabled to produce the modus ponens, and unable even to produce the strengthening of the antecedent rules. The strengthening of the antecedent means that if I have a rule like if A kills another person, should be punished, then I could derive, even if I kills another person, I don't know, on Friday, then, and I could add other premises to the antecedent, to the apologism, without them, all the propositions, because this is a logical rule. But this is a problem in non-monotonic reason, is a problem in law, because it's true that we can derive if A kills another person on Friday. But it's not true that I could derive if A kills another person in legitimate defense, then should be punished, because it's not true. Because in legitimate defense, it's possible to kill another in a justified way. And this is the problem. And this problem produces, in fact, two extreme accounts almost do not accept it for anyone. The first is the generic, strict generalism, total generalism, perhaps accepted by Kant, Immanuel Kant in the Metaphysics of Morals said this in Latin, this expression a lot of times repeated. The obligaciones, obligaciones is the E is disappear. Obligaciones non colliduntur, this is obligations are not in collision, do not collide among them. And this is the position really radical and problematic in the moral philosophy of Kant for a lot of reasons. For this reason, for instance, certain philosophers, David Ross, for instance, consider the obligations not establish a decisive duty, but prima facie in the terminology of David Ross, or pro tanto reasons. And on the other part, on the other extreme, we have the strict particularism, like in philosophy, in moral philosophy in the last years. Jonathan Dancy has a book with the title Ethics Without Principles, in this idea totally, and strict particularism maintains never we have a property, neither prima facie, because always is possible to find a new property in capacity to defeat the duty. But these extreme positions are very few people defending these extreme positions. There are people, but very few people. In fact, there are a range of intermediate accounts to this problem, a range of intermediate accounts. And the range of intermediate accounts I could present with this expression of another moral philosopher, but with publications in legal philosophy too, Schaffer-Landau, saying when our rights appear to conflict with other moral considerations, including other rights, we may resolve the tension in two ways: by reducing either the scope of the or its stringency. I think that these two ways of reducing the tension, of eliminating the tension, produces two accounts very different to the understanding the conflict of rights. The first, reducing the stringency of principles, amounts to consider that principles cover the cases even if they conflict, but that one of the principles supersedes the other, and in this way the first preserves its stringency and the second does not, since the second has lost its applicability to the concrete case. I shall deal here with one of these accounts, the most important in legal philosophy account, the proportionalist or balancing account, as it has been presented by Robert Alexi, whose ideas on the so-called balancing or weighting have been and is the most articulated and suggestive conception displayed in constitutional theory of the conflict of rights. It is very successful account, even successful from a legal point of view, because, for instance, the Constitution in South Africa, has a provision incorporating the three sub-principles of Alexi. That's very successful as legal theorist. It's difficult to think more successful than this success in the South African Constitution. Well, I think that this account has certain problems, and I would like to present here an alternative perhaps should be considered a modification of certain ideas of Alexi, but an alternative in the other horn of the possibilities of Schaffer-Landau, reducing the scope of principles, preserving their stringency, stands for conceiving the formulation of principles as incomplete and expanding it in a manner that conveniently hedges the scope of the principles remains different, and yet they do not conflict. This is the specificationist or expansionist account. This is very useful, for instance, in bioethics. If some of you are devoted to bioethics, in virtue of certain developments, is very useful, this approach. Well, first, proportionalism, as Alexi is able to present this idea, this very powerful idea, and my doubts and perhaps objections, 3,000 objections to the conception of Alexi. Briefly, I remember the conception of Robert Alexi. Alexi, for instance, present in this very clear way his conception in a paper in 1995, saying as follows: in the actual practice of many constitutional courts, balancing plays a central role. German constitutional law balancing is one aspect of what is required by a more comprehensive principle, namely the principle of proportionality. The principle of proportionality consists of three sub-principles: the principles of suitability, of necessity, and of proportionality in its narrow sense. All these principles give expression to the idea of optimization. Interpreting constitutional rights in light of the principle of proportionality is to treat constitutional rights as optimization requirements. That's the central idea, the core idea of Alexis. That is, as principles, not simply as rules. As optimization requirements, principles are norms requiring that something be realized to the greatest extent possible, given the factual and legal possibilities. The principles of suitability and necessity concern optimization relative to what is factually possible. They thereby express the idea of Pareto optimality. This is one of the reasons to consider the account of Alexi more or less consequentialist. The third sub-principle, the principle of proportionality in its narrow sense, concerns optimization relative to the legal possibilities. The legal possibilities are essentially defined by competing principles. Balancing consists in nothing other than optimization relative to competing principles. The third principle, therefore, can be expressed by a rule, the rule of balancing, that states the greater the degree of satisfaction of or detriment to one principle, the greater the importance of satisfying the other. The rule may be called the law of balancing, you know. In a very interesting paper, very short paper, judge and judge, legal philosopher and writer, Bernard Schling. Bernard Schling is the author of this very important novel and after novel on the Nazis period and after a very important film, even The Reader. And Bernard Schling said in this way, In short, enough is enough and more is too much. More than enough is out of proportion. More than necessary is out of proportion. More than appropriate is out of proportion. So don't do more. I think that it's a very good way to put the ideas of Alexi in a very brief, in a very condensed formula. Well, you know, the development of ideas, Alexi, this appears on the first time in the postscript of the theory of constitutional rights, in the postscript. But in the postscript, add this idea that it's possible to divide the interferences among light, moderate, and serious, and this allows Alexi to create this formula, the formula of balancing, because it's possible to attach a measure to the different rights, to the different principles, according with the interference is light, moderate. Light is 1, moderate is 2, and serious is 4. In this sense, it's possible to generate this idea. Adding another idea that I would consider briefly, the idea of the abstract weight of principles. This is a combination of abstract weight of principles and concrete weight of principles. And this is my doubts. My doubts are 3. The first doubt is about abstract weights. Because if would be possible to attach abstract weights to our rights, to our constitutional rights, will be possible to make a hierarchy of our rights, because it's possible to say the right the right to life has, I don't know, abstract weight to 10. The right of freedom of 8, I don't know, but makes sense, this classification, this hierarchy of abstract rights. I'm not sure. Consider the right to life and the right to freedom. How to classify that? Perhaps one could imagine a human society with total respect to the right to life and total disrespect to the freedom, like, I don't know, a general prison with security controls such strong that it's impossible to produce a threat to the life to the others, but this is all. Or totally right to freedom, but the possibility to be killed in some moment, in a very moment. That's, to me, this is impossible to compare. To me, this situation is a situation, it's us intending to compare between two circles of the hell of Dante. 2 circles of the hell of Dante is impossible to compare. They are very, 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 very bad circles. And in this sense, I'm not sure about the fecundity, about the interest to the idea of abstract weights. In fact, never Alexi put an example of this abstract weight. Never said. It's clear that this right is more is weighted than the other. That's one motive of doubt, one objection. Second objection is the scale among light, moderate, and serious interferences. Here we have a scale, but how should we assign one or other kind in a concrete case? We can only elaborate ordinal or cardinal scales when we have a clearly defined property, as it happens in the case of mineral hardness testing. Now a mineral a mineral is harder or mineral is harder than other, even only if the first can scratch the second and the second cannot scratch the first. You know that this is very, but the hardness of minerals allows us to elaborate and the scale, the Mohs scale. I cannot see how it's possible to do something similar in the case of the interference in the constitutional rights. In fact, in the case of Titanic, it's curious in the first expression, born murder, Alexis said, this is a light or moderate interference, but it's very important knowing to its light or moderate, because this is, from that depends the solution, and said light or moderate. And relative concerning cripple, said this is severe interference, obviously, hard interference. Obviously, I agree. But before that, the interference into freedom of speech is also hard. And in this sense, it seems a case of a slave made. It's not clear, even in Titanic case, it's not clear how works really the scale. That's my point. The third problem and most important, I think, is as follows: how to make compatible in Alexi the law of balancing. We know that with the so-called law of competing principles. This law of competing principles disappear in the postscript when Alexi confronts totally balancing with subsuming, and in the papers in 2000, in the 2000, disappears also, but recently, answering Alexi to Ferraioli and to Aaron Barak, this professor of Israel, very writing a very important book on proportionality, retrieve this idea. Which is the idea? The idea of derivative constitutional rights norms is closely connected with the first basic law of principles theory, the law of competing principles. For this law, two concepts are constitutive, are relevant. The first is the relation of precedence. This relation is symbolized by P. The second is the condition of precedence. It's symbolized by C. The result of each application on the weight formula can be expressed on this basis. The standard form is that. This formula expresses a conditional relation of precedence. Is to be read as follows. Principle PI precedes principle PJ under the condition C. The decisive point is that this conditional relation of precedence implies a rule. Precisely, this is expressed by the law of competing principles, which runs as follows. If principle PI takes precedence over principle PJ in circumstance C, then it is possible to obtain this rule, the rule saying if C, then Q. If C, then Q. And in accordance with these ideas, Alexi concludes, this is a highly specific rule that is justified by the Constitutional Court on the basis of competing constitutional rights, PI and PJ, in accordance with the two laws of theory. The law of balancing, as explicated by the weight formula, and the law of competing principles. A rule justified in this way, if the justification is correct, a valid derivative constitutional rights norm. Well, but I think there is certain tension between the two principles of Alexi, like Alexi presented. How should be understood the circumstances C? The apologies, the antecedent of the rule arising from the previous balancing. I would like to highlight that the fact that when we refer to the concrete way, this action amounts to one principle taking precedence over another in a particular case. Alexis stresses that interferences are always concrete interferences. In this way, then, circumstances C of all the properties instantiated by the concrete case, and the derivative rule only is able to solve this particular case, as it were. I mean, it is not possible to grasp a subset of relevant properties in condition to make the derivative rule a general rule. For the reason, balancing is a different device of subsumming. Subsumming presupposes generality, presupposes that we can identify certain relevant general properties that conjunctively can solve the case. In this sense, balancing is a particularist operation and ad hoc operation. I'm not absolutely sure about that. I think that there is certain ambiguity in the ideas of Alexi about that. Well, I presented some of these ideas last year in Lisbon and with Alexi present, and Alexi in the dinner told me I should reflect about that, but I'm not sure about his ideas now. But Alexi could be interpreted in the way that Alexi himself said in some occasion, that balancing is totally opposite to subsumming, and we have two ways of applying law, two ways, different ways. In certain cases, subsumming, perhaps applying rules is an operation of subsumption. Applying principles is an operation of balancing. This is one idea. The other idea is not so much. For instance, Manuel Atienza considers that the best way to interpret Robert Alexi is in the second way, is in a combination between balancing and subsumption. Balancing allows us to obtain a rule at the end, and this rule allows us to make the subsumption. And this is different. This is two ways to understand the process. In the first, there is an opposition between balancing and subsumption. In the second, there is no opposition. I am criticizing Alexi in the first version. In the second version is compatible with my account. I present my account now. But only I am criticizing Robert Alexi in the first version. Well, specificationist or expansionist in this case. Briefly coming back to the Lombardi-Balauri case. In Lombardi-Balauri case, it seems that the device of general rule or general principle and exception works very well. We can say, prima facie, pro tanto, we have a rule like if a professor expresses her religious convictions against some doctrinal dogmas of the university, and the university dismisses her for the reason the university is doing something wrong, forbidden by the law in virtue of being a violation of her rights. But the principle has an exception acknowledged by the constitutional Italian Constitutional Court. If a professor expresses her religious conviction against some doctrinal dogmas, the university dismisses her for that reason, and the university is a faith-based institution, a confessional institution acknowledged by the law. The university is not doing something wrong. But even in accordance with the European Court of Human Rights, it's possible to make an exception to the exception. However, according to this decision, the university should give reasons able to justify the fact that the religious opinions are contrary to the doctrine of the university faith. That is to say, the final rule said, if a professor expresses her religious convictions against some doctrinal dogmas, the university dismisses her for the reason. The university is a faith-based institution, but the university gives no reason for the dismissal, then the university doing something wrong. And this question of rule, exception to the exception of the rule is the life of the law, is the life of the legal reasoning, is all the days is in this way. Well, and perhaps also of moral philosophy, here there are certain important reflections about this aspect in some important moral philosophers, analytical moral philosophers, Richard Hare, David Wiggins. But at the end, David Wiggins said something that it's possible to use in order to justify the expansionist or specificationist strategy. Let me point out that it's only with the help of contextualists, said Wiggins, that we have any evident hope for formulating moral judgments that will hold universally and for absolutely all cases. That is, for all cases that fall under description that enter into the question that is under consideration. This is my idea. I developed for these cases in certain papers in English, even in these two papers sent for you, and in papers even in Spanish and in Italian, and a strategy, I set a strategy in 5 stages in order to produce between competing principles a way to hedge these principles and to solve the problem. We could take the Lombardis-Balauri case again. The first stage serves to delimit the normative problem by selecting not all the human actions that is impossible to manage with all the human actions, that only the actions constituting the universe of discourse. This is an expression very used, and the idea is from Alsuron Ibulin normative systems. Ascertaining the universe of the normative problem turns it into a moral tractable, a moral manageable one, by allowing us to focus on a small subset of human actions. In the Lombardi-Balauri case, the universe of discourse can be university professors expressing religious opinions. This is our universe of action. Not all the actions possible, all the human actions possible. The second stage is the identification of the standard and principles pro tanto applicable to this universe of discourse. Here, obviously, are applicable the principles which establish the university professor freedom of expression, academic freedom, in fact, and the legitimate interests of the faith-based academic institutions to preserve their religious conviction. The third stage consists in taking into account certain paradigmatic cases, actual or hypothetical, of the universe previously selected on the first stage. What's the idea? The idea is that the paradigmatic cases anchor our reconstructions. One reconstruction, one scheme, interpretative scheme, should be able to take into account the paradigmatic cases. If it's not able to take into account the paradigmatic cases, it's not convenient, it's not adequate. That is the idea. No? I put certain examples here. For instance, to express atheist convictions for a university professor of a public non-confessional university, you can see in Dawkins, in a non-confessional university is totally protected by freedom of speech, by academic freedom. And university professor of a Catholic university publishing a book explicitly devoted to proving that all Catholic dogmas are false and pernicious, it's a paradigmatic case to violation of the freedom, religious freedom of the institution, of the confessional institution. In the fourth stage, the relevant properties of the universe of discourse are determined. The relevant properties will lead to the normative solutions. In our case, the following properties are clearly relevant: the tenure position in a faith-based academic institution, and the presence or lack of reasons given by the institution in case of dismissal. And the last stage, the fifth stage, consists in the formulation of the universal standards for this context. In this sense, is contextual. Rules univocally applicable, but only in this context, in this universe of cases, and with these relevant properties. And obviously are in a non-confessional university. Professors have the right to express their religious convictions without limit. In a confessional university, the institution has a legitimate interest to protect the religious beliefs, and therefore is authorized to dismiss professors who express opinions contrary to the dogma, giving the convenient reasons. Well, that's how we could manage this universe of discourse and actions, and I could put this example. This is a way to show that with these ideas it's possible to generate a scheme able to solve all the possibilities. We have in the first possibility a confessional university with a professor expressing opinions against the religious of the institution, and the institution give reasons, then the rule authorizes the dismissal. In the second case, confessional institution, confessional university, but no giving reasons, non-dismissal. This is the solution. Is not authorized, the dismissal. And three is the case of non-confessional universities. We could think public universities. Public universities always is non-dismissal, the solution, in virtue with the rule 1. In this reconstruction is there is at the end the solution consists in showing that at the end is not a conflict at the end, because we are able to solve the conflict because it's only 4 possibilities. Or we are in the case 1, of either in the case 2, either in the case 3, or in the case 4. And this is no other possibility in this scheme. Obviously, it's possible another combinations. Obviously, it's possible imagine another property relevant in this way. For instance, it's some crazy possibility. A professor express a conviction, a certain religious belief, but connected and in order to provoke, in order because it's a clue to provoke I don't know, a terrorist attempt. That's another property, and in this case, change the scheme. In this case, change. But in this context, it's possible. And this is my idea. It's possible to obtain in this reduced way microsystems. Sources of law, this is the idea, constitution, legislation, judicial precedent, provide us only with the necessary elements, divisible principles, rules, and standards to construct normative systems given a certain context delimited by the circumstance of the case. And this is possible to define a context of use. In the case of Lombardi-Valauri, the set of actions of university professors expressing religious opinions, and a context of assessment, in our case, represented by the endorsement of two principles: the freedom of the religious expression of university professors enrolled in non-confessional academic institutions, and the protected interest of the faith-based universities to dismiss professors, giving adequate reasons who express religious belief contrary to its dogma. Relative to both contexts, we are able to get non-divisible rules R1 and 2, which solve all the cases of the previously delimited universe of this course. Relative to a contents of use and a contents of assessment, principles are codifiable and in non-divisible rules. Relative to this context, have the capacity to justify every individual decision and to provide guidance to judges in applying them. I realize that this idea calls for a detailed explanation, which I cannot put here, but the idea is in this way. And this is the idea we need in order to apply general rules. We need something like Aristotle said phronesis. When Aristotle said phronesis, phronesis is concerned with particulars as well as universals, and particulars become noun from experience, only from experience. And this is the point. This is not possible previously a priori to establish totally the rules. And even following Aristotle, that's I am not in some sense an scholastic philosopher, as some of you know, but in this case there is one consideration of Aquinas. In this way, Aquinas said in the Summa Theologica, said, "It's because the infinite number of singulars cannot be comprehended by human reason that," this is a citation of the Bible, of the Book of Wisdom, "our counsels are uncertain. Nevertheless," said Aquinas, "experience reduced the infinity of singulars to a certain finite number which occur as a general rule, and the knowledge of this suffices for human prudence, for phronesis." This is, in my view, very relevant expression. In this expression, there is this one expression of Robert Nozick in 1968. Robert Nozick wrote a very interesting paper called, and very difficult, Moral Complications and Moral Structures, but with a lot of aspects similar to my presentation. And Nozick was realizing the importance of legal reasoning on that, and said such a history, I imagine, would be common among lawyers who are familiar with the difficulties in devising rules to handle adequately in advance all the bizarre, unexpected, arcane, and complicated cases that actually arise, not to mention all the possible cases. Thanks a lot.
Thank you very much for your lecture. And now it's the time of questions. If you want to ask a question or make a comment. Por favor. Okay, so it's my role. I begin. I have two questions.
That's okay. That's okay. Questions.
The first question is related to the rule labeled R1 in your model of solution of the solution of Lombardi-Valauri case. You said that it is indisputable, yes, that in a non-confessional university, the professors have the right to express their religious convictions. And I'm not so sure, in fact, I'm not so sure that this rule is indisputable. For instance, because I think that in a non-conventional universities, the role of university professors is not to express religious convictions or religious belief. I would rather say that this is a private issue. The professor has to provide a knowledge to the students, yes? And maybe it's a little cultural difference of the background, but in my opinion, it's not indisputable. I'm not telling you that it's wrong, because maybe it's not wrong, but I think that one can debate whether it's right. And the second question is related not so closely to your lecture, but you mentioned also in the lecture, and you mentioned in one on the paper distributed for us, the theory of prima facie or prima facie duties of Sir David Ross. And I would like to know your opinion on the thesis that Ross, with his theory of prima facie duties, anticipated the theory of weighing and balancing of legal principles by Dworkin or Alexis, because in fact this idea of pro tanto duties means duties which are restricted by another pro tanto duties and are not definite duties until we make a deliberation. For me, it's very, very similar to the theory of weighing and balancing, and to the very same idea of legal principle, in fact. So these are two questions from my part.
Thank you very much. Thank you very much. Before the second, because it's easier to me to answer. I agree absolutely. This important book of David Ross, The Right and the Good, in fact, is in some sense an answer to the rigorism and to the inflexibility to the Kantian morality. And he imagines that it's possible to reconstruct our common morality in seven duties, general duties. But he said there are prima facie, there are pro tanto reasons in order to show that the complexity of our common morality. And in the book of David Ross, there is no development how to pass from pro tanto duties to actual duties in his terminology, actual duties. But in my view, it's obviously the same idea of this divisibility, the same idea of Dworkin and Alexis and so on. Yeah, I am convinced about it's the same idea. It's not, now moral philosophers prefer pro tanto duties because prima facie, and sometimes is not so clear in David Ross, prima facie seems something like at first glance, and there is no idea. But I agree, and I think that David Ross is a source of inspiration of this development, very relevant and very important. And on the other hand, this is another connection to my final appreciation of Aristotle and Phronesis. On the other hand, and this is important, David Ross is one of the best translators and knowledge of Aristotle. I mean, this is not trivial, this connection on the morality, the moral philosophy generated by David Ross and his knowledge of Aristotle, one of the best knowledge of Aristotle. Well, the first, I consider this question, and you are right. You are right. That's in a very nicest way to understand public university, in a very French way to understand public university. Perhaps even one could consider that it's prohibited, it's banned to express conviction, religious conviction at classroom, in the classroom. That's possible. This is not my. I decided do not introduce that. Didn't introduce that because was another complexity and was not my point. But I agree. I think that it's not impossible to put this question in this scheme, in the sense that in public institutions, in the context of a very strong license way, light way to understood and religion and to understand religious freedom. This is probably the consequence, and the other no. This is one problem in general, not only for this case, one problem in our comprehension of religious freedom, no? And I think that should be also in Poland. In France, for instance, they decide, and it's Conseil d'État, decide that is banned, is prohibited to show, to dress, to take religious symbols at the public space. And the school, for instance, is prohibited to go to the Chador and so on. But in Germany, it's permitted, totally permitted in Germany. And more or less, that's more complex. But in a very brief, very brief presentation, the European Court of Human Rights said like this is the margin of appreciation. This is covered by the margin of appreciation. Well, how we should understand the margin of appreciation in order to cover these cases? Perhaps, I don't know, it's a suggestion. And at the end of his life, Joseph Ras put a similar suggestion referred to the margin of appreciation. Perhaps if we consider that certain of our values are incommensurable, and in this sense, there are incompatible but legitimate ways to develop religious freedom, like other. It's possible to understand that in France, given his history, his self-understanding of the laicism of the constitution of the public space is legitimate to ban these expressions, and Germany, with another tradition, different tradition about religions, it's legitimate to permit, to allow this expression. But I'm sure. But thank you. That you are right. You are right in the two things. Thank you very much.
So please.
No question?
One
question from me. Thank you very much, Professor, for this lecture. I have one question because I'm not sure I understood you very well. Because also this answer to Professor Grabowski question convinced me of some problem because I think there is some problem with resolving the conflict between these very valid values, especially on this second case,
Marcos.
Yes, Marcos case. But this Lombardy Valverde is not so brutal.
Yeah.
The second is very. So maybe the problem with resolving this problem is not very logical, legal one, but it is more cultural problem. Because the hierarchy you talk about, you discussed, could be different, as you said, based on some cultural, historical, some
tradition.
So maybe there is no one logic solution to this problem or theory. But we can, it is very pessimistic to say it, but maybe it is in 90% the cultural problem. In Poland or in France, Poland more religious country, France less, in Spain and so on, the hierarchy is only based on some cultural experiences.
No, I see, you are right. Well, I am trying to hedge my account. My account is not able to solve the controversial questions and disagreements crucial in our societies. No, this is another question. This is another question. This is a question of normative and substantive arguments, and I'm not sure about that. I'm not sure. It's only like Alexei, intending to put a formal way to explain how it's possible to decide univocally in a universal way, contextual universal way, the cases, but not to solve the substantive questions. I mean, for instance, it's easier with the freedom of speech and personality rights, sides of personality, like the case of Titanic. Our course, at least in Occident, at least in the West, our course decided that when news published in a newspaper, in TV, is the public interest irrelevant, is the news produces what's the expression, not true, because demanding true is excessive, but true, or if not true, conveniently with sufficient evidence, no, like New York Times versus Sullivan and these cases, and the expression is not an insult, is not injury, is not an insult, then is protected. This is a general accepted version. Well, one could put in doubt insult, for instance, in the sense that in certain cases the refreshing democratic debate is interesting to admit certain expressions. That's okay. That's a substantive discussion. But my position is only a way to put in my paper in Ratio Juris. I explained how it's possible to reconstruct the case of Marcos, but saying that this is possible if we we accept the reasoning of the Spanish Constitutional Court. It's possible that no, it's possible that even in this case, like our Supreme Court, consider that this is not an action. The action in the case of Marcos was the action to convince Marcos to accept the transfusion. This is the action in fact, judging. Well, it's possible, as our Supreme Court decided that this is not covered by religious freedom. And my point is not on the content. My presentation is an account, a formal, if you want, account how it's possible to decide this case in a convenient way, taking into account the circumstances of the case, but able to highlight certain properties as relevant properties independent. This is my point. The other, you are right, and Professor Grabowski is right. I don't know. The other are question of the content. If you decide that Professor Grabowski said, well, this is not so clear that this property is irrelevant here in the rule 1, then we need change the rule and we need change our reconstruction. But I'm so sorry. I understand that perhaps some of you were expecting that which is my position. I have positions in some of these subjects, but it's not the point of this presentation. It's not the point, because the other is a normative discussion about. But it's in which position, in each position you choose, is necessary to reconstruct in this way. That's my point.
Please.
A few days ago, I read an article by Luigi Penaioli. I don't know if I'm
Yeah.
And he claims that, in fact, the weighting principles is unacceptable because of normative function of them. And what judges do is not weighting principles, but weighting some factual circumstances. And I just want to know your opinion on that field.
Yeah. I know this position of Ferraioli. It's an old position of Ferraioli. Well, I think that before one question by Cautela, Ferraioli said that because he has an account to application of law, it's very, very, very traditional, very Montesquieu way, in the sense that Ferraioli repeats and maintain this position. Voluntas and non veritas facit legem. This is Hobbes. Voluntas non veritas facit legem. But veritas non voluntas facit judicium. Veritas facit judicium. And in order to preserve this rationality, he defends. He is worried about the production of indeterminacy produced by balancing and so on. Well, that's my impression. But on the question, on the concrete question, I'm not able, and I discussed that with Luigi Ferraioli, I'm not able to see the difference between weighing principles or weighing circumstances, because it's the same. It's the same. The problem is the same. When he put the examples, traditionally before the constitutional discussion, in the first discussion of Ferraioli, more than criminal law and so on, the first book, Diritto e Ragione, law and reason. Of criminal guarantees. In this book, Ferraioli, discussing criminal law, put examples that weighing circumstances means deciding if applying or not self-defense necessity. This is cases clear of proportionality, of balancing, that criminal, I don't know, I remember Roxin said applying justification causes is a case of proportionality. No, balancing is a case of balancing. I'm not. I said Ferraioli that my impression is two ways of speaking. Is only notational variations, but no variations of content, and I think he preferred that in order to to maintain this image of this formal image of application of law. Now the formalist, but in fact accepts the same, because it obviously is metaphoric, saying that we weight and we balance principles, but it's obvious that we could say we are balancing facts inside of principles, but it's the same. It's the same. I'm not able to see clearly what's, perhaps Ferraioli is thinking in another thing that I am unable to see, but I know very well the work of Ferraioli, and I have no answer to that. I think it.
Thank you for the lecture, and I have a question. Is my intuition right? Because in this, the most common, the proportional way, we have rule versus rule, or the one is in some way winning, and the second one is there was a way, and the principle versus principle, we're weighting it. And are you proposing something like, the Marx did with Hegel, putting him from the head to legs? Because in this classical way, when we have the conflict with the principle and rule, we changing this rule to the to the source of the principle. And in your proposition, I don't know if I'm understanding it right, from the principle writing the rules in some kind of the university of discourse. And then we measure it, but not the proportional version measure in some kind, not based on quality, but in how many cases the result will have, the more frequently showed.
More frequently show the
showed like you showed on this table, like we have the three not rejecting, and one that said that we reject, Professor.
I'm not sure, but perhaps one of the problem is legal principles is used in a different ways, and so it's not always coincident. But I think you're right that, and even in my presentation, we could consider principles as general lines able to be applied, to be implemented in different ways. I sometimes I said to my students, principles should be considered as themes of jazz. It is possible to execute in jazz this theme in different ways, but this is the same thing. And I think so perhaps this is an idea to understand principles different of the idea more this dichotomy in Dworkin and Alexei that is problematic. This total separation is problematic. It's problematic even in one thing elaborated by the first criticist. I remember perhaps even Alexander Pechenik, that if are two animals, two birds so different, how it's possible that principles make exceptions to rules? How is possible the principles are able to make exception to rules if there are two things independent, absolutely independent, and rules set working applies all or nothing, and Alexei applies always no. It applies in relation with validity. It's valid. It's it is not declared invalid, or then it's applicable. But it's not true, because principals are able to avoid the application of rule. I think that it's better to conceive the difference in another way, and I said in certain papers, recent papers, that in the last 30 years, for the influence of Alexei and Dworkin, the image of law for many people, and for us, for many people, as law is to flats building. In one flat lives rules, in the other flat lives principles. But the difficulty is how it's possible that principles goes to the down to the rules and put exceptions, and that's very difficult. The formalist image is criticized for obvious reasons, that one flat only of rules produces a formalistic and inconvenient image of law. But perhaps it's possible another image. One flat, one store building, one flat, but living in the flat, not only rules, but also underlying reasons able to go to these underlying reasons in virtue of defeaters in our law. Defeaters, a lot of times justification causes, but constitutional fundamental rights could be conceived as defeaters, allowing to the organ applying law, applying rules, to go to the underlying reasons. I said, claiming certain understanding of my position, I said that defeaters working like gargoyles in the Gothic cathedrals, something like that. And this image perhaps is more convenient, and I think it's better than the image to a store building is produces certain distortion of our understanding of law. But that's my intuition. That's my intuition. I should be, and I am thinking about that, and I have the intention to publish certain things about this, and this idea that my proposal now would be something like make, even if I could, but even writing a book with the title Rules and Reason, a Theory of Legal Reasoning. This is my idea now.
Rules and reasons.
Rules and Reasons, a Theory of Legal Reasoning. Rules and Reasons. Because this is the contraposition, no? This is the jurisprudence of rules, that's for some people Hartian, Razian jurisprudence. The jurisprudence of reasons said sometimes, Schauer, for instance, saying Dworkin, more or less jurisprudence of reasons, and this contraposition between rules and reasons in the sense of underlying justifications of rules, in this sense. I think that legal reasoning is a question of rules and reasons. Is a question, is a double question. Is like, sometimes it's a question of rules, and in some jurisdictions a question only of rules, clearly, but sometimes it's a question of rules and reasons, and this is the peculiarity, in my view, of legal reasoning. It's a question of rules and reasons. I don't know. I am able to produce certain ideas connected, concerned your worries. Thank you.
Are there any questions? So I have one more question.
Obviously.
You know, I'm not a specialist on meta-ethics and so on, but on didactical level, when we deal with the things like this, we usually the concepts of ethical or legal ethical absolutism on one side, nihilism on another side. In between, it's relativism, of course, and a little bit beyond is this thesis of value pluralism of Berlin and Russ and its awful word, I don't know if to end this word, incommensurability.
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 Thank you.
Yes. So normally we discuss, we have this set of concepts, and I wonder because I'm not sure this position of specificationism or expansionism, in which place you can put, you would like to put it? More close to absolutionism,
Yeah.
or to relativism. You know, I'm interested in your opinion. I have some intuition, but my intuition is not important.
Oh, that's important. That's important. And in metaethics, there is a very huge discussion. And well, before it's important to distinguish between the discussion about universalism or generalism said sometimes and particularists, because particularists, for instance, Jonathan Dancy, are not necessarily relativists. They think that in this concrete circumstances, the right solution is that. In this circumstance, but it's impossible to predict how is the correct solution, the right solution, before knowing all the circumstances to produce. This is the idea of generalism and particularism is one idea. The other is the idea of which is the space of objectivity in moral reasoning. Well, absolutist is very strong, and absolutist is not so friendly to say I am absolutist, but my account presupposes sure that there is a space of objectivity in moral reasoning. Presupposes certain space of objectivity. Objectivity is understandable in different ways. There is objectivity for moral realism, that the reality is in some way has a moral dimension. But there is constructivist positions. There is possibility, for instance, role set. A moral judgment is objectively true, even if it would be accepted for all in conditions of rationality. And well, that's possible, this constructivist approach. There are a lot of constructivist approaches. I am for years and published certain papers, one paper after all on Carlos Nino, defending constructivism. Now I have a doubt. I have no answer to an objection, very easy objection to constructivism, but very easy to formulate, but I am not sure which is the right answer to this objection. The reason said, if constructivism is true, then one proposition like, if in ideal conditions, we consider that is right, torturing babies by fun, then torturing babies by fun would be right. That's it seems is a consequence of accepting constructivism, but it's a very, very odd consequence. That's if constructivists should accept one proposition, conditional proposition, counterfactual, saying that even in ideal conditions, we accept, we consider, we desire, I don't know, that torturing babies by fun, then torturing babies by fun would be right. Produces a lot of insatisfaction. And I am not sure how to answer this objection. I'm not sure. And in this sense, there are in the supermarket of metaethics, there are a lot of products. And it's possible, for instance, this is important in political philosophy and in legal philosophy. These important philosophers connected with the colloquium NYU, Ronald Dworkin, but Tom Nagel, Tim Scanlon, Derek Parfit. Derek Parfit are defending something like a anti-naturalist moral realist, but without metaphysical commitment, without they say it explicitly, without metaphysical commitment. The sense I like to compare the discussion of philosophy of morality, philosophy of metaethics, and philosophy of mathematics, because in mathematics, the philosophers always discuss about what is the mathematics presupposes the existence of numbers, of ideal entities different of us, and that is true. How we could connect, we could know these entities, well, that's problems, but it's possible to defend a Platonist conception in philosophy of mathematics, or constructivist, or even fictionalist, or a lot of conceptions, but nobody for this discussion is from Plato to our times, but nobody considers that there is, for the reason, no objectivity in morality in mathematics. Everyone accepts that there is objectivity in mathematics, even if they disagree. They disagree explaining explaining this objectivity. They disagree, but they accept the objectivity. I think that it's similar is our practice of moral evaluators. All of us consider that I don't know, commit treason to the friends, torturing babies to fun, is bad. It's bad. It's wrong. It's wrong. Oh, our common sense morality is there are certain questions, certain principles widely accepted. That perhaps it's enough with that, and the discussion of the reconstruction of this fact is an unending discussion, because this is philosophy. It's an unending discussion. It's a discussion, yeah, from Plato now. One important philosopher, English philosopher, Alfred North Whitehead, wrote with Bertrand Russell, Principia Mathematica, said provoking once all the history of West philosophy is only footnotes to the work of Plato. But footnotes to the work of Plato. Thank you.
Please. Are there any questions? So thank you very much, Professor Moreso.
Thank you very much. Thank you very much.